Hello everyone, welcome to another episode of the Digest for Competition and Innovation Laws. Today we have with us Professor Pankhudi Khandelwal. She has completed her undergraduate from NLIU Bhopal and having completed her master's from London School of Economics, has researched extensively on the intersection between antitrust and digital markets. Thank you, Professor, for taking out the time to talk to us today.
Thank you so much for having me over.
We can now move on to our second segment, which is based on consumer privacy and antitrust. Especially in contemporary times, we see a lot of debate and discourse on the intersection between the two. And this is particularly post the CCI probe into WhatsApp. Ekjot, if you could take over.
Yes, thank you so much. So moving on to this very specific problem of privacy concerns and competition law in general. So the first question that comes to my mind here is that given this emerging discourse surrounding the interplay of antitrust and privacy concerns, do you think that the two of them can converge, or should they be separately regulated by the concerned regulators?
So I think they should be converging. And again, this is my own opinion because we have different opinion on this. And this is a very sort of subjective question that's been going on in the law debate. But I think that it should be converging because when we talk about data protection law, so we do not have a data protection law in India, but I'm talking about it in the say, GDPR perspective as well. Even globally, this has been seen as an issue that even in GDPR, we have provisions which are used by these companies such as for fulfillment of contract or for legitimate processing or based on consent, for which we have not found any solution till yet, right? So consumers do not still have control over their data. So I think competition law is required because it basically imposes a special responsibility on these dominant undertakings, which is what we need, again, because we want these dominant undertakings to be taking more precautions. Right. So I think competition law should be sort of used to regulate data protection because I don't think data protection law in itself is enough to deal with these dominant undertakings. And I think competition law sort of imposes more obligations on them, which is more beneficial for other competitors as well, because then they also sort of, when they enter the market, they know what to expect. So I think that way competition law should be intervening, and it should be intervening on the basis of abuse of dominance, because again, we can see the sort of breach of privacy as, and this is what was pointed out in the Germany Facebook Federal Cartel Office decision as well, which was later sort of stayed and which was later sort of relied on by the Supreme Court on the basis of consumer choice. But I think it is a manifestation of abuse, right? I think that Facebook is able to sort of not comply with GDPR because because they know that, it will not create any problems with their position of dominance, because the consumers are so reliant on Facebook and because of the network effects that operate in that market. So I think that competition law does need to intervene to make sure that the privacy aspects are taken care of.
Professor, if I just have an added question. So, bring up GDPR. I think one angle of it is that dominant enterprises violating the GDPR because they're so dominant that consumers don't have a choice. But I think recently, with regard to the Apple Spotify case, which is going on in the EC at the moment, Apple is relying on the GDPR to deny Spotify access to its app. Potential access to its app store, or even charging high subscription fees. So do you think sometimes using GDPR or holding a high privacy standard can be used to actually sort of facilitate abuse of dominance? That's what Spotify is contending. Or do you think that may be possible as well, where someone at the behest or using under the aegis of privacy, they can actually deny data? I think because that's what's happening elsewhere as well.
Right. Yeah. Yeah, I do agree that, again, I think it will come down to balancing both the sort of respective acts, so GDPR and the competition law, because we need to sort of see, again, because there have been a lot of cases where even when we talk about IQ versus LinkedIn, I think, again, the whole thing comes on balancing as to how much privacy we want and how much of data sharing is or should be allowed, right? So I think that it is it is something that needs to be decided on a case by case basis as to how much privacy you actually want, how much weightage you want to give to the privacy aspect. But again, I do think that privacy aspect should take, if not precedence, then it should not be compromised, because that's something that even in India we have privacy as a fundamental right, and even in EU we have that as a right which is sort of more supreme than your business rights or your competition law, sort of rights under your competition law, right? So I think that privacy should not be sort of compromised with. But again, there needs to be a sort of balance as to, and we need to recognize cases where privacy is not actually being hampered, but actually just being used by the dominant entity to sort of foreclose market for certain competitors. So I think with Apple, the thing is, again, because Apple is also denying access to Facebook as well, right? So I think I think it's a welcome sort of step, because Facebook basically takes more data than users actually allow it, or even for that matter, Google takes more data than users allow it. So I think in that respect, it could be a good thing, because you would be encouraging more competition based on privacy. But again, that's also something that we decide on a case-to-case basis, and there needs to be certain parameters. I think that will become clear once the decision is made by EC with respect to the Apple Spotify case. But I do think that privacy concerns should not be compromised. So even if Apple is using it as, say, an excuse to not provide data, I think you still need to be very careful as to how much access you're allowing for other apps to actually take data from users' devices.
Sure, Professor. I think the point about balancing is the key in this essence, given that we still do not have a data protection legislation in India. So, talking about balance, so can you please give us an example to say how do we determine how much should a competition regulator intervene in such situations where the primary question is about consumer privacy, or the primary question is only related to the data that has been collected by the players?
Right. So I do think that the role of competition authority should be only limited to see whether there's an abuse of dominant position, right? So only when you see privacy as a factor of a non-price parameter competition, or when you see privacy as something which is being a breach of privacy happening because the company is so dominant that there are no other competitors to actually challenge that. Because we've seen this recently when WhatsApp changed its policy, that people were actually moving to different competing sort of networks such as Telegram or Signal, which sort of shows a good step as to the fact that consumers are also realizing the importance of privacy, and then that stopped WhatsApp from changing its privacy policy, at least for the time being, right? So I think that competition authorities' role should be limited to only, firstly, only to dominant entities and not to other entities. And it should be limited to see whether there is enough competition to allow privacy as a quality sort of parameter of competition. So again, this will also have to be seen in the light of the CCI versus Bharti Airtel judgment, because as of now, we don't have a data protection authority, right? But we do have an Information Technology Act, which is sort of regulated by the High Court. So I think, again, this would also come into the jurisdictional aspect, that CCI cannot sort of, so it might happen that CCI must have to first send the case to the concerned authority. Also, when we have the Personal Data Protection Bill, which would be passed, and there would be an authority under that. So they might have to first give the case to them. And once that determination has been made, then CCI can take cognizance of that matter. So I think CCI's role would be limited to that, especially because we already have a sort of working way of dealing with matters that intersect with each other. But again, there are a lot of problems that arises in that sort of mechanism as well, because how much would CCI be intervening would again be something that needs to be determined on a case-to-case basis, because it's not a very clear, even the CCI versus Bharti Airtel judgment is not very clear as to how you sort of see the technical aspects or how you see the competition aspects. So again, it's very sort of, it's a question which is being debated a lot, and we do not have clear answers as to how much the CCI can intervene, but I think it should be just on the competition factors, because if it oversteps or it tries to sort of see whether the company is actually complying with all the data protection regulations or complying with all the Information Technology Act, that's where it sort of steps away from its own jurisdiction. And then again, we have Section 21 and 21A under the Competition Act, which sort of looks at, which provides this cooperation framework, which is not something that is relied on a lot till now. But I think, again, that is something that would become useful in the digital economy cases.
Sure, Professor. So you just mentioned about the WhatsApp privacy case right now. So coming to that case, since it's a very hot topic given in this moment, so we know that CCI has taken suo motu cognizance of WhatsApp because of its privacy policy. And similarly, something Germany also in its Facebook case took cognizance of such privacy concerns. So do you think we can make a parallel over here, that the WhatsApp case and this Germany Facebook case are kind of similar? However, Germany at the same time also has this special GDPR legislation. So what is your take on that?
Yeah, I think it's a very sort of welcome step from CCI to actually try to enforce this. I think it was basically long overdue, because CCI has sort of refused to first take jurisdiction in the previous order, which was Sri Vinod Kumar versus WhatsApp, and WhatsApp previously changed its privacy policy. So I think it's a good sort of direction for CCI to move forward in, because again, CCI, so yes, as you rightly pointed out, there is a parallel, because here also CCI relies on the consumer choice, and they do not look into the data protection of, provisions as such, but they say that the privacy policy does not give that choice to the consumers to actually choose not to share their data, which is again, because, and they look at the network effects. I think they do a more thorough analysis when it comes to the dominant position of WhatsApp, which is what they didn't do earlier, because there they did not look at network effects at all. And they said that, there are other competitors and that there are other choices that consumers can rely on. But now that you've seen, now I think CCI has become more sort of advanced in its approach, because they looked at network effects and how it's so difficult for consumers to actually move to some other competing social media network, which is why I think it's a good sort of decision. It's a good, direction to move when it comes to privacy and competition law. And I think CCI has sort of, I don't think it has overstepped its jurisdiction as well, because it has restrained itself to just consumer choice, which is what was done in the Germany Federal Supreme Court judgment as well. So, and when it comes to, again, I think Germany, the fact that Germany has GDPR, and even after that, the Germany's Supreme Court gave this decision, is what sort of gives us this idea that CCI should definitely, I think, look into this, because we do not have that relevant authority as of now. And I think even when we do, again, I think based on the mechanism that is followed, it might happen that these questions are first determined by the Data Protection Authority. But I think CCI can always sort of jump into this, and then they can sort of provide, fines or provide certain remedies that needs to be followed by these dominant entities to make sure that they're not violating the privacy obligations. I think one problem that can arise with respect to this, and this is something that I talk about in my paper as well, is that there could be forum shopping where people think that, because again, the amount of fines, and this is something that happens even when we talk about the interface between competition law and consumer protection law, because consumer protection law, you have lesser fines, but competition law, you have more fines. So again, that would lead to forum shopping as to determining where do the informants actually file a complaint. But again, these are a few of the things that we have to now talk about, given that we will be having three sort of separate authorities that can potentially have jurisdiction in these matters. So yeah, I think, but for now, I think the WhatsApp case is something that was long overdue, and that CCI has actually, I see it as a good step for the privacy concerns that arise in India.
Thank you so much, Professor. Professor, just leading from some of the questions that just previously asked, specifically regard to the German competition authorities Facebook case. I think a lot of articles which I read post the decision came out was that the competition authority essentially shed a lot of jurisprudence on privacy rather than actually focusing on competition law per se. And only later, I think they did change their decision to only competition, or stating that it was not a privacy concern, it was mainly just an abuse of dominance per se. So do you think sometimes these competition authorities may abuse, their own level of expertise when deciding upon these cases, given the fact that they definitely lack at a certain level of expertise to regulate uh, digital matters? Because I think it was only until 2019, post the market study, the e-commerce market study, that the CCI even began to regulate, began formal proceedings against, platform markets like Make My Trip or even Facebook and WhatsApp. So you think without this necessary lack of expertise, you think they're well equipped to actually decide cases regarding privacy and especially consumer protection or data privacy, given the fact that even the PDP bill isn't really passed as yet? And if the PDP bill is passed, we've hardly seen, like you stated, Section 21 or 21A being relied on by the CCI, whether it's in the Erickson judgment, like the IPAB never got to decide. They did get to decide, but there was a conflict of jurisdiction. So do you think there may be some form of harmony that can be struck, because in the past that really hasn't happened? So that's just my question.
Right. Yeah. Yeah, I think the competition authority, especially CCI, would have to be very careful when they're exercising jurisdiction in these matters, because it so happens that because these are not matters which are, which are sort of disjointed. You cannot sort of say that, okay, this is the data protection matter and this is the competition matter, so you just decide on this. It's bound to happen that when you're deciding the competition issue, you might actually look at the data protection issue as well, which is why I think CCI needs to be very careful, and which is why I think there was this resistance by CCI to sort of decide this in the Shri Vinod Kumar case. But I think it can be, there could be a sort of proper guideline that CCI can have with respect to how much intervention they can be allowed to do. And again, with respect to Erickson judgment as well, so yeah, that's true that they provided for concurrent jurisdiction, and that was based on what remedies they are giving. So I think in that case, basically they saw that compulsory licensing remedy and the remedy that was there under Competition Act were sort of, basically compatible with each other. And this is something that was challenged in CCI versus Bharti Airtel, and then in Monsanto Holdings case, they have said that both these judgments, hold true. So again, there's a lot of, because again, the kind of Erickson case was differentiated based on the fact that that CCI and TRI are basically two different regulatory authorities, but basically the IPAB and the CCI are sort of completely different when it comes to how they operate. So I think there's still that aspect also which would have to be looked into as to what kind of an authority is the data protection authority and what kind of jurisdiction they have under that act, and whether that is something that can be, said to be compatible with CCI's jurisdiction. So these are the questions that would essentially arise once the PDP bill is passed. But I think that CCI needs to be still very cautious about how much intervention they are making in these kind of privacy matters, because they definitely cannot, overstep their jurisdiction, because this is something that is not at all provided for under the Competition Act. So privacy is not an aspect that we see at all in the Competition Act, and we just sort of include that based on the factors that we see under Section 19 Clause 3 and 19 Clause 4 as to sort of weigh the efficiencies versus the harm that is brought on by the dominant entity. So I think CCI's analysis should be limited to just seeing privacy as a factor of competition, and not to see whether the entity is actually complying with the data protection obligation. So I think what CCI can basically see is whether there is enough sort of competitive constraints to allow competitors to basically compete based on privacy. So I think that question should be the only thing that CCI determines when it deals with the privacy aspect.
Oh, yes, Professor. Thank you. I think with regard to specified legislation, I think the EU was recently trying to enact the Digital Markets and Digital Service Act to only regulate the strategic entities. And I think the Competition Amendment Bill also tries to bring about this change, but I think due to COVID, that has sort of been stopped from being enacted. Professor, just have a couple of questions left. So I think primarily why, aspects of consumer privacy, or even, consumer having no choice between one platform and others, because of the lack of interoperability and data portability amongst these platforms, given the fact that they operate within these ecosystems. Like Android ecosystem cannot use their own data, transfer it to the Apple ecosystem in case you want to switch. So do you think such a remedy enforcing some form of data interoperability or portability sort of reduces privacy concerns that exist at this moment?
Yeah, so I think they can definitely be sort of good good behavioral remedies to give to sort of make sure that there's more competition. I think the technical aspect as to how this will happen is still a big question, which is why I don't know if we can rely a lot on these technologies, because we do not know how this is going to sort of function when it comes to, say, Facebook trying to port data of users to other entities. And also then that also sort of raises certain privacy questions as to how this sharing would happen and how much of the data would be shared, and how that sharing would happen in the sense that, whether it would be, what are the safeguards that these entities would have to follow so that this data is not actually misused by any third party. So I think that would there would be a lot of technical aspects that we will have to think about. Interoperability, again, I don't know. I mean, it would be a very good remedy, but it's a big question as to how this would function, especially when it comes to markets which are not interoperable as of now. So we have telecom, which is interoperable. We have, say, finance sector, which is interoperable, but we do not know how interoperability would sort of function when it comes to, say, social media markets or a different sort of other markets that these entities are sort of functioning in. So I think that these can actually be quite efficient remedies, because, again, the whole advantage that all of these dominant entities are enjoying because of network effects would basically be countered through these remedies, right? So network effects, the reason that people cannot move to some other competing apps from WhatsApp is because they do not have enough of their friends on that, or they do not have enough of their other sort of contacts on that. So I think that would be effectively countered through interoperability, because then they can sort of make sure that they are actually being able to connect to other people through, say, if they can message to someone's WhatsApp through their Telegram app. So I think that would be something which would make sure that there is more competition in the market, and there's more competition based on privacy in the market. But again, how that will happen is, I think, a bigger question as to what effect it would create. So, and again, the same thing with data portability as to how, because again, how do you shift the data from one entity to another, and because again, there are a lot of technical questions as to in what form the data will shift, what are the problems that can arise, because again, I think that would bring out problems of hacking and bring out problems of other things, which needs to be countered to make sure that data is actually being sort of, shifted in a safe manner and not sort of breaching the privacy of consumers. So I think, again, it might be easier, but there's another problem that it might be easier for dominant entities to comply with data portability, but it might be more difficult for smaller entities to have that kind of infrastructure to allow, shifting of data from one company to another. So this might actually lead to more sort of competitors leaving the market because they are unable to sort of invest in that much infrastructure. So again, these are the questions that we need to sort of consider when we think of these two remedies, because it might actually not be very feasible when it comes to operating in a more practical manner.
All right, Professor. Thank you so much. I just have one last question. So, I mean, given the fact that we've spoken about so much about data and the importance of it, several regulators are now looking at us when competition regulators are beginning to discuss upon, whether whether platforms' conduct is anti-competitive. They're almost looking at it from sort of a refusal to deal angle, where refusing to deal to provide certain aspects of data is anti-competitive. So, don't you think this is sort of leading to or seeping to applying the doctrine of essential facility to consumer data?
Yeah, I think so, because again, when we're talking about data portability or interoperability, I think what you're doing essentially is applying this doctrine, right? You're saying the basis for this is basically saying that data is essential for us to operate, which is why we need this data, and which is why you need to share it with us. I think this is the same thing that happens in the HiQ versus LinkedIn case as well, because they're not saying that they're applying this doctrine, but in a way they are, right? Because HiQ is being allowed to access LinkedIn's data, which LinkedIn should basically have sort of authority to see how the data of their users are being used, but they are being allowed to take that data because it's essential for them to run their business. So I think what that case does is basically apply this doctrine without saying that they're applying this doctrine, because they say that, again, that case is with respect to the interim sort of state. So I think when the court sees that case, they say that, it's basically very essential for them to operate their business, which is why that is if harm would be caused if they are not given this data. So I think in a way they are sort of applying the essential facilities doctrine, because what they're saying is that this business cannot function without the data of LinkedIn users. So I think it amounts to applying essential facilities doctrine. And if you see, it's not the essential facilities doctrine has certain sort of ingredients which need to be fulfilled. And if we see the history of this doctrine, it's basically, apply to say railroads, or apply to electricity, or apply to oil, which is something that we thought, that access to these sort of facilities would be required because we do not want duplication of the infrastructure. We do not want two sort of telecom, entities operating with their own lines and with their own wires, which is why we allow them to have access to each other's, infrastructure. So I think when we see essential facilities history and we see the ingredients that are required, which is indispensability, and that all effective competition is eliminated, I do not think that these ingredients are present when it comes to the digital markets or when it comes to access to data, because again, data is a non-rival resource, right? So just one entity having the data does not mean that other entities cannot have that data. So I think that is how competition authorities are circumventing into saying whether essential facilities doctrine applies to data, because essential facilities doctrine cannot be said to be applying to data, but the way that we see digital markets are functioning, data is required to be shared from these dominant entities, because data basically operates on the 4Ds, right? So you need the volume of data, you need the value of data, you need velocity, and you need veracity. So till the time you do not have enough data, you cannot actually use that data to your advantage. And this much data can be only accumulated by these big tech companies, which is why we require them to share this data. So I do agree that, they are basically, it amounts to applying the essential facilities doctrine, but I think what the authorities do is they circumvent through this doctrine and they try to say that data is essential, but they do not say whether this doctrine applies or not. But in a way, asking them to share the data or asking them to make the data portable does mean that you're applying that doctrine.
All right. Thank you so much, Professor. Yeah, I think, I mean, even recently, even in the FTC and the ECB, always look at them sort of treading on this aspect of applying the essential facility doctrine. And at the end, they just back away and they look at it strictly from the refusal to deal aspect. I think this was even in the Microsoft or Google shopping or even the Google Android case. I tried exploring those aspects of applying the doctrine, but it never really did. I mean, obviously, I think it would make the market more volatile than it actually is at the moment, and a lot of investigations will begin if they actually apply the doctrine. Professor, I just have one last question. So I think right now, what we're seeing, even when you look at Amazon's market structure, the way they've sort of pursued their plan to sort of concentrate the market is, privacy concerns are reducing and anti-competitive conduct, it's sort of increasing. It's sort of inversely proportional. So do you think you can sever, does both conduct merge within the realm of competition, or can they be actually separated?
I think they do merge. I'm not sure about, because with Amazon, the problem is that they do take data and they do use it to their advantage. But with Amazon, we have other sort of abuses as well, where they're using that data to sort of give preference to their own sort of goods, or to sort of make sure that other competitors cannot compete in the market with Amazon. So I think I don't think you can sever the privacy sort of issue with other competition issues, because I think all of that, if a competition authority is looking into the competition issue, they are bound to look at the privacy issue, because it's because of that much data that Amazon is able to gain that dominance. And I think with Amazon, the main service is Amazon Web Services, which relies mostly on data, which is what is used to finance their other vertically integrated sort of operations as well. So I think that is the problem. That is basically why you cannot sever the privacy issue, because and that is why we call these companies as big tech, because they are relying on the data, which is why you cannot sort of, if you try to sever them, it would not be, you cannot get the whole picture of the market, because a problem that arises with modern antitrust as well, because we are not able to, the reason that we're not able to understand these markets is because we do not see the principles that have been followed in competition law so far to be applying to these entities. Because when it comes to predatory pricing, these entities have so much investment that they do not need to increase it. So I think this is why we need to have a more sort of holistic approach, because you cannot understand these issues without understanding everything that goes in the market.
Thank you so much, Professor, for your time. This has been incredibly insightful.